Hi, my name's Steve Aitken. I'm Managing Director of Aitken Real Estate. And joining me today, which we're very pleased to have, is Colleen Buck of Cheltenham Conveyancing. Welcome, Colleen.
Thank you, Steve. Thanks for having me.
Pleasure. Well, I should introduce, by way of introduction with Colleen. Colleen is founder and owner of Cheltenham Conveyancing, has been 34 years doing conveyancing.
Correct.
And won licensed Metropolitan Conveyancer of the Year in 2014.
Correct.
So she brings a wealth of experience to today. And we've got, Colleen, we have got dozens of questions that have been emailed in.
Terrific.
So let's get started and get stuck into
Thanks,
it.
Steve.
So first thing is, I guess, what is a conveyancer? What do they do?
A conveyancer is a person who conveys, basically we transfer titles. So we do all the legal paperwork involved in transferring a title from a vendor to a purchaser and, likewise. So we also do transfers of land for people, we do subdivisions. So we're exactly the same as a property lawyer, except we solely concentrate on conveyancing.
Okay. So for our viewers, the difference between a conveyancer, a solicitor, and a licensed conveyancer, because you're a licensed conveyancer.
All right, the licensed conveyancer, the difference between a conveyancer and a licensed conveyancer is that we've actually got the qualification to be licensed, to hold our conveyancing licence. With solicitor, we very much do the same job as property lawyers. However, you often find in a law firm that it's the law clerks doing the conveyancing, because in some law firms they have litigation, they have probate, they do lots of different areas of law, whereas with conveyancers, we're doing conveyancing day in, day out. It's all we do. So it's the licensed conveyancer that actually handles your transaction.
So what's the difference between, say, a licensed conveyancer and a conveyancer?
They don't have the legal qualification.
Okay.
Yeah.
Fantastic.
Basically. Yeah.
So anybody that's looking to do this really should use a licensed conveyancer.
Absolutely.
Okay.
Absolutely. Yeah.
So let's get stuck into some of these questions. One of the things is, as a real estate agent, so my clients often ask this: why does it take so long to prepare a Section 32, and what is a Section 32?
Okay. A Section 32 is a disclosure statement to a purchaser about a property that you're selling. Why does it take so long to get a Section 32? That's a funny question, Steve. It's because it depends on how long it takes the client to get back to us with their initial instructions.
Okay.
So if you're thinking of selling your property, the first thing you need to do, is contact your conveyancer.
Yep.
And start and give your instructions to the conveyancer. We have some people that ring up and they say, my auction's in 2 weeks. Well, some of the certificates that we need to apply for from councils take 3 full working weeks to come back.
Right.
So we need as much notice as possible. And then I normally send out a vendor email to my clients, which is a list of questions about the property that I need answered. The minute you get those answers back to me, that's when we open our file. Okay. Absolutely.
So I know that in the past, for some of our viewers here that have been watching, there's a difference between Section 32 or a vendor statement for a house as it is opposed to a villa or a unit or an apartment. And these things with owners corporation, how does that, I mean...
That's one of the things that holds us up the most, to be honest with you, is because in the Act, the Owners Corporation have 10 working days to provide that certificate. You can pay extra fees and get priority certificates, but it's often the one certificate we're waiting for is the Owners Corporation's, and it's extremely important certificate.
Yes. Extremely
important, because at any given moment, a Section 32 is only valid for as long as the information in it is still correct and it hasn't changed. At any time, an owners corporation might strike a levy and it has to be disclosed in this statement.
You've got to redo the Section 32, is that correct?
Yeah.
So again, for everybody watching when they're selling their property, and this is particular in Victoria, in Australia, we're in Victoria, it's really important to understand that as an agent, we can't sell a property legitimately, or it's not legally binding without that Section 32.
Section 32.
Yeah. So it's in people's best interest if they're thinking about selling or they're definitely going to sell, really, even before actually appointing an agent, they actually probably should go and speak to you.
Yeah.
And just while I've got you, so because we've had a long history with Cheltenham Conveyancing, one of the things is I do know your phone number off by heart, which is it's 9585 6222. So if you're looking to speak to Colleen after this, definitely give her or her staff a call. They're wonderful to deal with, and they'll certainly sort you out. But continuing on the theme of getting these Section 32s ready, we as agents, when somebody puts it on the market, sometimes that they speak to us, they say, yes, let's put it on the market, and then they go, oh, we say, you need your paperwork, go and speak to a conveyancer or a solicitor, whoever they choose, and then we've got this huge delay. Now, we often as agents go, hurry up, please, get us a Section 32 today or tomorrow. Where does that leave you?
Well, we can only produce the documents once we've been instructed and we've applied and received the certificates. I'm a very prudent, fussy conveyancer.
Yes.
So I like to make sure that I've got every aspect of the Section 32 covered before I release it. Sometimes we get asked questions by agents, well, can you give me what you've got so far? Right? We can't do that, because if you go and rely on that and there's something vital missing, then the contract becomes, can become voidable at the option of the purchaser right up till settlement. So we could have a 90-day settlement, and on the 88th day, 2 days before settlement, the purchaser can withdraw if the Section 32 is defective. Right.
So that's really important for everybody to understand, because some people have come to us and they also drag out an old Section 32 that they've had maybe a year ago and say, well, look, let's use that, and try to slide it by.
Yeah.
That's a no-go, is it?
No, absolutely.
Okay.
No, under the Act, you have to provide purchasers with current information. So, and anything could change.
Yep.
Anything could change, and we really need our clients to be honest with us and tell us exactly what's happened at the property. Have there been any building approvals in the last 7 years?
That's a great thing to come up now.
It's amazing how many people forget that they've had building approvals in the last 7 years.
Well, that's one of the questions here, is that I've done an extension, or some building is actually what it says, from Matthew, and Matthew says that he didn't happen to get a permit. Okay. Where does that leave him?
Well, technically speaking, depending on what work he's done, like the classic is the pergola or the decking.
Yes.
Right? So many people just put it up themselves and they don't get a permit for it. Technically, it's an illegal structure because they haven't got a permit for it. And then the property gets sold with an illegal structure. If the purchaser chooses to take out title insurance and something goes wrong, for example, someone might let the council know that, or ring the council and say, oh, I'm thinking of buying this property. Can you tell me if it's got a permit for the great big veranda?
Yes.
And the council will look up and they say, no, it hasn't. So the council will go, oh, I might go out and have a look at that property and I'll serve you with a building notice.
Right. So is that likely to happen prior to settlement? Or if it happened, we're just checking that some people are writing in. If that happens prior to settlement, that leaves the seller with a significant or potentially a significant problem, yes?
Absolutely, because if there's a building notice on the property, a purchaser wouldn't settle with a building notice on the property. So then the vendor has to comply with the building notice and have it removed. So it would definitely, depending on what stage of the transaction it's at, it would definitely slow settlement down. If I was acting for a purchaser and I'd apply for a building certificate that will tell me what building approvals have been in the last 10 years, and more importantly, if there's been any notices served on the property. And then I would go back to the vendor's conveyancer and say, I'm putting you on notice that I refuse to settle until the building notice is removed, because technically it's a defect.
What happened? Is there been a case where the property settled and then for some reason they're found out? Is there any retrospective action that a buyer could take?
Once settlement takes place, it's pretty much a case of, it sounds bad, but it's almost like bad luck.
Yeah, sure.
But you always have rights. Absolutely. What I would suggest to a client, and we have had things like this happen many, many times, is go to VCAT.
Right. Oh, okay.
Yeah, so VCAT's cost effective. The application, I believe, is less than $100.
Yes.
I can't remember the exact amount,
Sure.
but that's not expensive as opposed to going to the magistrates court.
Yep. And
you know,
employing
3,000.
solicitors. Yep.
Absolutely. So you do have that recourse,
Okay.
but obviously it's best to try and get everything sorted before settlement.
Okay. So let's go to a couple of these questions. What is the difference? This is from Karen and Bob. What is the difference between purchasing a property at auction compared to a private sale?
Okay, good question. Because at auction, when you purchase, you're purchasing unconditionally.
Yes.
So there's no wheeling and dealing like you do with a private sale. You can't write special conditions in,
Right.
which
Now,
is something that's
perhaps,
really important.
Perhaps we should explain to the viewers now what a special condition is.
Okay, it's a specific term of the contract.
Right.
So, for example, and this is something that's really important, if you're going to buy a property and it's being sold by private sale, not auction, make sure you write everything that you need in the contract into the contract.
So,
for example,
yep.
there's an old car, that's rotted car that's been sitting on that nature street.
That the seller said, I'll get rid of, I'll get rid of?
Yeah, of course he will. No,
sure.
unless it's written in
Yes.
that the vendor will remove the item prior to settlement at their own expense. Yeah. This is an essential term of the contract.
Okay. Yep.
Because if you don't have that wording, then they don't.
Good intent doesn't necessarily make sure that they do.
Really important.
And we've been caught out occasionally too, Colleen.
Absolutely.
So going back to that is that special conditions also, which is something that agents do all the time, is subject to finance. Now here's a one.
Not necessarily a special condition, but
it's part of a condition.
Yeah.
Okay, so subject to finance is one that comes up with us often, and I understand. So you can clarify for us and our viewers is that if it says Thursday the 30th or the 30th of July or September or whatever, does that mean that special condition expires at that time, the finance clause, or is there there's extra time, isn't there?
Absolutely.
So how does that work?
In the general conditions of the contract, you have 2 days to notify the vendor in writing as to whether your loan is approved or not. What happens, I had it happen to me this morning. Loan approval was due on Friday on a particular property, and this morning I got a letter saying we need an extension of time for loan approval. So they're within their 2 days. So if they'd waited till 5 o'clock or after midnight tonight, that contract would have automatically gone unconditional.
Right. And there's no ifs, buts or maybes about that, is it?
And what most people try and do, though, is they give you more notice than that. They normally don't leave it to the last 2 days. But sometimes people are so desperately trying to get their finance through that they say to us, don't ask for an extension yet, don't ask yet. The broker says we're going to get it today, And I just always say to them, give us plenty of warning, because if we get caught within that time, you can't walk from the contract. You have to go ahead with it. Speaking of that, Steve, another thing that's really important, if you're thinking about buying a property, please do yourself a favour and go and organise with your finance people what you can and can't borrow, get pre-approval.
Yep.
Because what happens and what causes a lot of angst between people is when people go along and sign a contract subject to finance, and then you commonly get told Commonwealth Bank are running at 20-day turnaround now for processing.
Are they really?
Or the like.
Yep.
And so you have to go back to the vendor and get an extension of time for settlement. It causes anxiety to the vendor because you can't put your sold sign up because it's not sold. So they're going, oh, we sold. We thought we'd sold. Do we start looking for something else?
Yep.
Oh no, it doesn't look like they're going to get their finance. The purchaser's anxious because they want to buy it, and they can't confirm this. They can't. That sold sticker's not up. It's not theirs yet. So it creates a lot, and for conveyancers, it creates a lot of extra work for us, going backwards and forwards all the time.
And there's an old thing by the agent that says you only need a week. We then leave all that problem to the conveyancer.
Yeah.
Is that a pretty fair comment?
Yeah, absolutely.
And let them get the extension off, but it all looks good at the time.
And it creates a tension between the vendor and the purchaser, which you really don't want.
No.
I mean, I've had situations where in negotiations the vendor said to the and something's gone wrong throughout the transaction, and they've said, well, now I'm not going to leave the cubby house. If you had done the right thing by me, I would have left this, this, and this.
Yes.
So you've got to try and play the game, but that's really important with regard to finance. Is get it organised first.
So finance is really strong. The other thing is, I think we got interrupted by a phone call. iPhones aren't working that great today, Colin. The other thing that comes up a lot is building and pest and building inspection.
Really important.
Now, from a purely buyer's point of view, it's quite critical, isn't it, for them to have building. Well, not always a building inspection, but if they're going to use that provision, we as agents usually are only interested in whether it's structurally has structural integrity, but the writing of these special conditions, I know in the past we've actually rung you and said, this is what's required, please give us a special condition. I find that much easier to do rather than make it up myself. I wasn't a bad bush lawyer, but I'd prefer the conveyancers to do.
There's fairly standard clauses for pest and build. It's really interesting that in New South Wales, virtually every purchaser gets a building inspection, and in fact, in some of their legislation, it's part of their Section 32 that a building inspection's done.
It's got to be done.
In Victoria, few people get building inspections done,
right.
And depending on the wording of the special condition, and this is why, depending if you're acting for a vendor or a purchaser, you don't like people just drafting special conditions willy-nilly, because it depends on.
You're looking at me when you say that, Colour.
The wording is crucial. It would be. Acting for a purchaser, I would love to have a special condition that says we want to get a building inspection done subject to our satisfaction. Right?
Yep.
That would be great.
Yep.
But the vendor won't agree to that.
And from the agent's point of view, we're not really entirely happy about that either.
That's right. So normally the building inspection, like the standard building inspection clause, generally provides that you can only withdraw from the contract if there's a major structural defect. Now, what people don't understand is most things aren't major structural defects. Right. I get this all the time. We've had a building inspection done. The window frames are rotted. There's downpipe spouting needs to be fixed. And the list is as long as your arm of things that need to be. Not any of them are major structural defect. So. And then people say to me, well, can I go back and renegotiate the price? And I said, well, you can try, but it probably won't help.
I can tell you it won't happen as an agent.
And I also say to people all the time, most properties, even if they're brand new, sometimes they have things go wrong with them. All properties need maintenance.
Yep.
So generally speaking, what comes back in that building, the great thing about the building inspection and report is you know what you need to address first when you buy the house.
Yep. Okay.
Same with pest. And with pest, often it just means it needs to be sprayed.
Okay.
That sort of thing.
All right. One of the other questions is, and I think you covered it, when do I approach a conveyancer in the selling or buying process? So what you're saying is, as soon as possible, when you think of it, which is really important. The other thing that has come up, and actually I think Mary and Grant have sent in this. What is a chattel? So we in the business, we as agents, and I'm sure as conveyancers, we think we know what we're talking about when what a chattel is. Mm-hmm. And I know we've pre-empted this because we let you know. So what is a chattel?
Well, according to Osborne's Law Dictionary, it's a movable, tangible article of property.
Right.
So it's basically something that's going to stay with the property, but you can move it. Some dishwashers could be considered chattels. Right.
So are they generally, though, today, because they're, under bench and...
We list them as part of the, fixtures and fittings. And generally speaking, a fixture is something that's affixed to the land, technically speaking. So there's a lot of grey areas. Right. Like there's been a number of cases go to court regarding speakers. Because everyone has a lot of people have their home entertainment systems.
I think you're bringing this up because the one we sold last night, Colleen, has huge speakers bolted to the floor. Mm-hmm. It has a projector sitting up there, and then there's a television. And I know you prepared the Section 32 vendor statement for this, and in fact, I noticed on it excludes the projector and the screen, and there's a television mount. But in fact, we added, because the vendor, just in case, we added, and the speakers are excluded as well, because even though they're
bolted.
Yeah, bolted to the floor. We just wanted to be safe.
Yeah, and generally speaking, and that's why one of the questions that we ask clients when when I'm getting the instructions for the Section 32 is, are there any chattels that you, or any items at all that you specifically want included or excluded from the sale? Yeah. If you put it in your contract, there's no confusion about it. So, and that's really the best thing to do.
Clarity.
That's absolutely, because then it's not, well, I thought that was staying.
What about Aunt Mary's rose that they want to dig up out of? They've decided, Aunt Mary gave me that rose.
Yeah.
It's been there. It's not in the contract. They dig it up, a week before settlement, pop it in a pot and take it with them. Yeah. How does that travel?
I always say to people, communication is the best method. So I would contact the purchaser and say to them, this has got sent to me. Firstly, I would hope that my client would tell me they want to take, because I would put excluding the rose in the front. But then also, at the time of negotiation, I would say to the purchaser, you can see from the contract I'm taking this rose bush, but I will replace it. Okay. Would you like me to replace it with a particular colour rose bush? Yeah. And they might say, no, I hate your garden. I'm going to pull all those plants out when I get in here, and I'm going to concrete everything. Or, so it's just really a matter of, negotiation.
Polite, isn't it? And it's polite.
Yeah, absolutely.
There was one that we did ages ago that there was quite a new dishwasher, and it was a Schmeg, or it was one of the high-end brand dishwashers. In a final inspection, and we must address that, but in the final inspection we went through, and to the dismay of the buyer and to us, I must admit, we looked, and it had been replaced by a Kelvinator or something about a third of the price. Now, the buyers did notice it, and certainly had a huge discussion about it, and it was put back. But does this come up from time to time?
It does. It's quite astounding what some people do. It really is.
Right.
I mean, it's just like, you've got to look at things like, how would you like to be treated like that? It's like, I often get the phone call from people saying, before settlement, they've gone to do their final inspection and they're so disappointed because the house it's an absolute mess. Right. Now, legally, and it is disappointing. I mean, I know, yes, there's going to be boxes everywhere because people are moving, but there's a difference to have boxes everywhere and a difference to something being absolutely filthy.
Yep.
The grass is
Are they required to fix that? Is that
legally, the property is to be delivered to a purchaser in the state it was when you signed for it.
Right.
General wear and tear accepted.
Okay.
So, if and often people forget, like they'll ring me and say, "Oh, there's a broken window in the laundry." Was the window broken when you signed for it? I don't know. Did you check? I don't know. So no, I didn't. Did the hot water? The water pressure's terrible. Or this tap isn't working. Or did you check when you signed for it? No. Well, then the vendor will say, "Oh no, that's in the condition it was when you signed for it." So we get that all the time. I'll send a list of things we want this done, and we get the reply: the property is in the condition it was when you signed for it.
Okay. So just if you've joined us recently, my name's Stephen Aitken from Aitken Real Estate, and I'm talking with a true expert in conveyancing, Colleen Buck of Cheltenham Conveyancing, and you can grab her at any time at 9585 6222. She is definitely worth talking to because she knows a lot. Let's move on to some other questions. I think you've sort of covered this. There are problems at my final inspection. That was what we were really talking about. Tell me, when can a buyer inspect? What's their lead time in for a final inspection? Can they do it 2 weeks? Can they demand multiple inspections? What's the situation?
It's legislated that it's 7 days.
Right.
Within 7 days prior to settlement.
So,
I mean, people can negotiate to do it earlier than that. The one mistake that a lot of people make, they leave it too close to settlement. Yeah. If something is wrong, it doesn't give us enough time to fix it.
Okay.
So, and then some people say to me, "Oh, I want to do it the day before settlement because I want to make sure that they've packed up everything and it's clean," all that sort of thing. Like you get a variety. But generally speaking, I had a request this morning about a final inspection where the purchaser said, well, I'm coming to do my final inspection, I'm bringing a building inspector with me, I want to get a building report done. My client emailed me and said, is this okay? And I said, well, it's really up to you. They're entitled to their final inspection anyway, but it's unusual that they have a building inspection at the end.
Once a buyer's signed and once the seller's signed, except for polite and reasonable access, but there's no requirement for the seller to provide any other access other than that final inspection, is
Correct.
there? So you need to be, as a buyer, really clear about this. Most agents and sellers that we've had dealings with over 30 years have been quite reasonable. I'm sure that you've found the same. But there have been from people from time to time, for a variety of reasons, that said no. And buyers get quite put out by saying. But the fact is that there's no right.
Correct.
Okay.
Correct.
So the other thing that that's come up, I'm just looking for. Why do I need an owner's corporation certificate? This goes back to villa units and apartments and all the rest of it. We know we have some angst over this.
Well, it comes back once again. It's part of disclosure under Section 32. You have to let a purchaser know as much information about a property as you can. So the owner's corporation certificate will tell you what the current fees are. They'll tell you if there's any special levies.
Yes.
They'll tell you what the insurance is over the property. Most importantly, it'll give you a copy of the minutes of the last annual general meeting. And and I always say to my clients, have you read the owner's corporation certificate? No, that's what I've got you for. And I said, well, yes and no, because I'm not going to be living there. You are. So you need to know what the rules are. You need to know that you can't put an advertising sign up.
Or pets.
Exactly.
Yeah.
Pets. So it's really important, and that's why you can't, as part of your duty of disclosure as a vendor to a purchaser, you have to include an owner's corporation certificate. There are 2 units on a site is exempt, so 2 units now are exempt for, you don't necessarily have to provide.
Oh, okay.
We always do anyway, regardless, Steve. We put a certificate in saying that it's a non-operative owner's corporation.
Well, while you're talking about this, a really good topic, little question that's been asked. The reason is that on sites where there's, say, 3 or 4, and we did one not too long ago where it was the front unit, there were others around it, but it had its own separate entrance. But what they said was there was no active body corporate per se or owner's corporation. How does that work? Does the owner's corporation certificate still have to be dealt with?
Absolutely.
And who does that then?
Well, the seller will have to do it. The only way you can get around it in that situation is that even if you've got your own separate entrance, but your unit still forms part of that owner's corporation. So you're at the front here and the other 2 behind you share the driveway.
Yep.
You've still got a legal responsibility
because of the common area.
Correct.
Yep.
So if there is no insurance, and it astounds us all the time, people say, oh yeah, no, we haven't got any owner's corporation insurance for the common driveway, we just rely on our own insurance. When there's more than 2 on a lot and you've got common property, you have to have public liability insurance for the common property.
So what that means is if you walked up to see somebody or a friend came to visit them and they fell down and broke their leg, they could sue everybody?
Each unit owner.
Yeah.
So say I fall over, never work again, sue each 3 individual unit owners personally if there's not that common property.
So this is a great tip for any person living in a villa or any area where there's no active body corporate, and for whatever reason that there's no public liability insurance that's derived from everybody. You should attend to it. So there's worthwhile.
It's actually if you take out an insurance policy with like a strata insurance policy with your public liability insurance, and you cover all 3 units, all you have to do every year, one person nominates to say this is your 3rd share. It's actually cheaper for you from an insurance perspective than it is to individually insure.
Fantastic.
So what we have to do with some people and this situation comes up all the time, because most people, there's only 3 of us, we don't really want to have an owner's corporation, we won't worry about it. But when you sell, we have to get you to take out, and we say to people, well, it's a cost of selling, you need to have it. So they actually, for the purpose of selling, take out a common property public liability insurance policy.
So Yep.
So
So
that
this
they're
adds time and effort.
Absolutely, and
so-
money. I say to people, well, I can't prepare a Section 32 for you without that document. It has to have the common property public liability insurance. The policies cost around about anywhere between $300 and $400.
Right.
And I say, as a vendor, if you want to sell, you have to go and get this insurance policy.
And this is something that people selling or thinking of selling really need to understand, that as an agent, what happens is if somebody walks in with a huge suitcase full of money and they're prepared to pay lots of money, if we don't have, any agent doesn't have the correct paperwork, we can't legitimately take the proposal or
Correct.
offer or sign the contract. And agents want to do, and I've heard salesmen, we certainly wouldn't do it here, but I've heard salespeople say, we'll sign off the contract subject to receiving the Section 32. How does that stand legally?
It doesn't.
Yeah, so it doesn't stand up.
No.
We're aware of this,
Yeah,
so people
absolutely.
like to play the game, but it's not true,
Intent,
is it?
notice of intention.
No,
to
notice of
purchase,
intent. That's another.
it's
That's
just,
a cutie one.
Yeah, it's not worth the paper it's written on.
Correct.
Okay,
Yeah, no.
basically.
I know that, and
Yeah.
I think we've been told plenty of times.
Yeah.
So we don't use that.
So no,
Yep.
you have to have the correct paperwork, and it's all really about protection, disclosure, and protection for the purchaser. And you'll want the same things for when you go to buy.
Yeah.
So you want to, and so we'll say to people, look, if you're looking, then let us have, before you put in your offer, get the agent to email us a copy of the contract in Section 32 so we can check it out.
That's a great look. Just from my point of view, it is another thing that's come up. We as agents, and I know many agents do, and we do in particular, when a sale takes place, that what we do is we send you a hard copy, and we also email you a copy, and we do that for both sides of the transaction. Let me ask you this, and this is one that nobody's written in about, but I'm just quite interested. Is there any legal requirement on the agent to send you those documentation, or send you that documentation, or does that really fall within the parameters of the seller should send it anyway, or at least notify you? Where does it sort of all go?
Well, we rely on real estate agents to send it to us, otherwise, because people, it's amazing, they forget to tell us things.
Right.
I have so many vendors that don't ring me and say, oh, guess what I sold on the weekend?
Right.
So if you don't send it to me, I don't know.
So, but where does that fall? If something goes wrong, as has happened in the past with, and I'm sure it's happened to everybody, where does that leave both the seller and the buyer and the agent? Is there any precedents that you're aware of, or does it all end up in court?
I would imagine that there'd be something in the REIV that would say that it's your obligation to provide.
I don't know whether I've actually seen it,
the vendor's representative.
but we do, and I think you would reasonably expect, and it's something to remind sellers and buyers either to make sure that your agent is sending the documentation so you could ask the question, or at the very worst make a call to your conveyancer or text. I mean, most these days would shoot them an email and say, by the way, we've sold it, please look out for the contract. Yes?
Yeah, absolutely.
Okay.
That's great. And then if by chance it does get missed, and recently in the last 2 weeks I've had 4 different contracts that haven't been sent to me from real estate agents.
Well, there you go. So
and exactly. So I said, oh, the client's called, and I said, oh, I didn't know you sold. I haven't received the contract yet. So we chase it up, obviously, straight away. So it's really important that we get the contract, particularly if it's a 30-day settlement.
Okay.
Particularly important that we get the contract
that's
straight away.
Actually great question. Great something to come up. What's the quickest settlement you can do? All things being equal.
Well,
so
if you've got cash.
Yeah, so it's not subject to finance.
Yeah.
It's not subject to a pest or building. It's not subject to Aunt Harriet looking at the property.
Yeah.
What's the quickest settlement you could do?
Well, the majority of people have banks involved, right? So a lot of it depends on how quickly your bank can work.
Okay.
Your conveyancer, we can meet anything. I can meet a 7-day settlement if I had to. If you didn't have a bank involved, if you had cash.
So if you had cash and we came to you and said, everything's fine, bank's not a problem.
Provided, once again, depends on who the vendor's bank is.
I was just going to say.
Because, say, for example, I'm selling a property and I've got Commonwealth Bank. Their turnaround is at least 15 business days.
Right.
So they're saying to you, if you're selling for us, because the Commonwealth Bank discharge team is now in Sydney.
Right.
So
It used to be in Victoria?
Yes.
Okay.
So they need that time, that turnaround time, to be able to take instructions. They go, okay, Mr. and Mrs. Smith sold. We've got to get that file ready for a discharge. The conveyancer will have asked for the Section 27 letter.
Right.
We've got to get that ready as well.
We've got to cover Section 27, Colleen. We've really got to cover it because Section 27 is release of deposit. That's for a seller. And of course, we might add at this point that the agent gets paid at the same time. So we're all pretty pleased about that. We've got to be honest. Section 27, as I said last night, a client of ours, we sold the property. The first question that he asked was, I really want to get the deposit. We actually rang our buyer, the buyer that was involved, and said, look, from your point of view, there's going to be some documentation that comes through. Our client would like to get that release of deposit as soon as possible. They said yes. What's the situation now?
Well, a lot of people mistakenly think that your deposit's released 28 days after the sale.
Right.
It's not necessarily the case. There's a procedure to it. So when we prepare a contract for a client and a Section 32, we also prepare the Section 27.
Yes.
So prior to preparation of the documents, we get all the instructions from the client, what's owing under your loan. Is it a line of credit? Have you got redraw? What are your interest payments? What your monthly repayments? What's your interest rate? Etc. etc. And that document gets served on a purchaser. They also have to be given a letter from the bank in support of the Section 27. So when we write off for this guy that sold last night,
yes,
we write off to his bank and we say, we get him to complete a discharge authority.
Yes.
Some of the banks now are doing them online rather than the old paper forms.
Yeah.
Like, for example, Westpac, the client can either get online and fill it out, but they always have to make sure they photocopy it and give us a copy because we need it to be able to get authority to act with the bank. And we write off to the bank and say, property sold, this is the settlement date, we need you to prepare a discharge of mortgage and we want a letter in support of the Section 27. When we get that letter, and it can take quite a few weeks for banks to get those letters to us, so we say to our clients, start and chase up your bank. Victoria's the only state in Australia where deposits get released before settlement. So because settlement departments like CBA are in Sydney, they go, oh, Victoria again. So they don't have that system. So it can take weeks. Banks can be slow at getting these documents out.
So this is when sellers start ringing us looking for deposit, and why agents start ringing you going, we'd really like our release of deposit because we get paid. Thank you very much. Is that right?
That's right.
Yeah.
That's right. And a lot of times it's out of our hands. We're not deliberately, it makes no difference to us when you get your money. We know it's important to you guys.
Absolutely.
We only ever get paid on settlement anyway. But
so that's the difference though, isn't it?
That's the difference. So if you want your deposit released as soon as possible, get to your conveyancer, fill out your discharge authority, and we get it to the bank as soon as possible, then start hassling the bank.
So these are great tips that you should make a note of when you're going to sell or you've sold, and hopefully these will sort out a few issues. That's also brings up a couple of things that Maxine's also asked. New cooling off provisions in a contract. So here's the scenario. A buyer looks at a property, makes a proposal, puts it on a contract, everything's great. There's no special conditions per se. So there's, no subject to finance, it's not a pest, but they, for whatever reason, they go away, they have buyer's remorse, which sometimes happens. Aunt Fred or Uncle Fred says, that, why did you buy there? Or, there's a whole run. They want to cool off. Now, in Victoria, there are cooling off provisions.
Correct.
How does that work, Colleen, and what's involved?
Okay. Recently there's been a good court case recently in relation to cooling off. It used to be that a purchaser could just cool off directly. They'd serve notice in writing to the agent.
3 days, 3 business days.
You've got 3 days to cool off. So if I sign a contract today,
which is
Tuesday,
yeah.
So Wednesday, Thursday, Friday. So 5 o'clock Friday, cooling off period finishes.
Yep.
Okay.
Yep.
So. But it used to be that a purchaser could serve notice on the agent saying, I exercise my right to cool off under the contract.
Yes,
the contract's
we've had them
end.
from time to time.
But now, in this court case, it was shown that it has to come from the the purchaser's representative that they've cooled off.
So that's their conveyancer or solicitor.
Correct.
Yep.
So what I do for my clients, if they call off, and it's very rare that clients do call off.
They do, that's true.
But they do sometimes. I say to them, it has to come from me. I have to serve a notice on the agent and the vendor's conveyancer or solicitor, advising them that we've called off. But I also suggest that you do it as well.
Oh, okay.
So we're doubly sure. I know it's double dipping.
Does the agent does the agent have to respond, or does once they get the notice, that's it? Do they have to acknowledge having received it?
It's best if they do.
What happens if we just put it into our bottom drawer and go, didn't see it?
Well, I always ring and make sure you've got it.
Oh,
Right. So
how unfortunate.
We always ring and make sure that the agent's got it and everyone's and for the vendor too, so that they know. Because generally speaking, they say they'll call you and say, "Quick, put it back on the market straight away."
Absolutely.
Sort of thing. So,
I've got the other question with the cooling off provisions is sometimes when a property is sold, but often by people don't want to pay their initial deposit straight away. Now, under the provisions of the cooling off period, it's if they just straight cool off, it's 0.02% of the purchase price. So that can be a substantial amount of money. It's a couple of sometimes we know we've seen it as a couple of $1,000s. If the agent doesn't take a deposit and the buyer cools off, clearly there's no money to be gained. I suspect that the seller could have a fair old dip at the agent. Should.
Well, yeah, absolutely, but. And this happens all the time,
It's very unfortunate.
Because what happens is most people, they'll go and they'll put in an offer and they might put $500 to $1,000 down until loan approval is due in 14 days, and then they'll make the payment of deposit the same date generally as loan approval. Yeah. So you're holding your $500 and the property's sold for, I don't know, say, for argument's sake, $800,000.
Yes. There's not a lot.
Yeah, that's right.
There's not a lot left, is there?
That's exactly right. So it depends it depends whether the vendor wants to pursue it or not. Yeah. Most often than not, they just say, "Don't worry about it.
It's too hard.
Too hard. Yep. Just resell it."
Look, again, my name's Stephen Aitken from Aitken Real Estate, and I'm talking today with a true expert in conveyancing, Colleen Buck from Cheltenham Conveyancing. We've been going a fair while, Colleen, but we've probably only covered of the email questions. We've barely, not even made half, I don't think. Do you mind going for a few more minutes?
No, that's fine.
Okay, so. We've covered Section 27. There's another thing that we've been approached. We just won't have a bar of it. There's agents receiving kickbacks from solicitors or conveyancers regarding money. Now, we won't have a bar of anything from anybody, whether it be a conveyancing company such as yourself or a supplier of anything, which I think is just good ethics and keeps everything at arm's length. How do you feel about all that?
Well, we know that there are conveyancers out there that do provide some sort of secret commission, I guess you would call it, in some format to agents. And I know a lot of real estate agents that will only refer to conveyancers that pay kickbacks. We don't. As a member of the Australian Institute of Conveyancers Victoria, we're very ethical, and it's illegal to pay illegal commissions.
Well, the other thing is you can't stay in business be in business as a conveyancer for 34 years if you lack integrity.
Absolutely. I would much prefer to get a job, be referred to someone because I'm going to do a good job for that person than because I have to pay you for it.
Sure.
So, and I'm very fortunate that my clients come back all the time, so I must be doing something right.
Well, you do work, and just so as everybody, all our viewers understand this, you do work all over Victoria, don't you?
Yes.
You can do it.
I've got a couple of files in Mildura as we speak. So
another thing that comes up from that point of view, is there a difference in, and if you're looking to use somebody to coming up to do a conveyance, give Colleen a ring. As I said, 95856222. Make sure that the plug is already there because you've been great with your time today. The other thing is there a difference in cost between a box doing preparing for a seller or acting for a buyer? Is there a difference in cost?
I don't charge differently.
Right.
I should specify though, it depends what the transaction entails.
Sure.
So it's obviously there's a lot more work involved when people buy in a self-managed super fund, or if they buy in a trust situation.
Okay. Yeah.
But for everyday mums and dads buying and young people buying and selling,
Yes.
we charge the same amount per file. The varying factor is the disbursements.
Which is?
So the disbursements are all the out-of-pocket expenses in relation to the file. So for example, costs of rate and planning certificates, title search fees, we charge a file archive fee, a settlement fee, there'll be, with new electronic conveyancing coming up, there'll be PEXA settlement fees, which will be a little bit different again.
Right.
So they're all the things that we have to apply for. So you come along to me and you say, Colleen, I bought a house, I want you to do the conveyancing for me, how much is it going to cost? Generally, I will have looked at the Section 32 for you first.
Sure.
I can tell some there's conveyancers and solicitors that,
Sure.
that are really thorough, and there's some where there's
Like
just
all?
nothing in there.
Yeah.
So I'll say to the client, look, there's absolutely nothing in that Section 32. I think we need to apply for a full set of rate and planning certificates.
But that's not a benefit. I think some people think that you're doing it for you.
Yeah.
But when in fact what you're trying to do is protect for the seller and for the buyer, and everybody walks away.
Absolutely. And often that's when we find out things like you'll see in a Section 32, it'll say no building approvals in the last 7 years. I apply for a building certificate from the council and it'll come back to me and it'll show that there was a building approval for additions and alterations 3 years ago. So I go back to the vendor's conveyancer and say, hey, your Section 32 is defective because you've said there's no building approvals. I've got a building certificate. There is building.
And
who did them?
Yeah,
was it a registered builder? Was it an owner builder?
Right, and this is really important because one of the things that we get trapped in is that when we're acting for clients too, we take what they're saying at face value, and so we can be in the middle of a sale, be in the middle of a negotiation, can end up really well, and all of a sudden these problems poke their heads up. So again, I encourage you as an agent, I'm saying, to really go and see your conveyancer, speak to Colleen or any of her team, but speak to your solicitor or conveyancer, whoever you're using, earlier, and be quite candid, both with your agent as well. That's another thing. Agents get caught out in these things because we all of a sudden we find that the information we've been given isn't quite correct. Let's just move on to a couple more. Well, let's have why don't you have a good old go at us agents, Colleen? There's a couple. I think this might have been one from your office. What do agents do wrong? There's the list is probably endless, but
promise things they can't deliver.
Yeah, no, that's probably. Let's talk about that. So what is probably the biggest gripe? Because sellers and buyers need to understand this from a conveyancing and an agent's point of view. Where does it all go wrong for agents in the deals?
Look, it depends. Obviously, every case is different. But one thing that the agent shouldn't do is, as we touched on earlier, is tell clients you're going to get your money in 28 days because there's a process and not necessarily.
What about this one that comes up? This one comes up with us all the time. So what happens is we've got a settlement date.
Yep.
So we're one of the things that a buyer will say to us is, here it is, we'll settle on the 1st of October, but look, there's no problem, we'll probably bring it forward to the 15th of September. Now, from my, as I said, 30 years experience or 60 years odd between us, Colleen, we've probably worked out a few things, but my first comment is whatever's on the contract is what goes. Everything else goes through the conveyancers and solicitors. That's our opinion.
Correct.
That's right. But that's it, isn't it? Yeah. Whatever's there, it doesn't matter what they say, it's what's on the contract.
That's right. And what we often get is, but the agent said that the vendor was really flexible with the settlement date. Well, what's happened in the interim, though, is the vendor's gone, okay, well, I'm settling on the 1st of September, and so I've bought another property that's settling on the 1st of September, because it is, regardless, what most people don't realise is it is best to have your settlements on the same day.
Ah, okay.
We have so many people ring up and they say, I thought I'd make it easier for you, I've made them 3 days apart. No, it doesn't make it easier
Right,
for
so
us.
Settlements, there's another great tip. Settlements on same day.
And I'll tell you why. You need the money from your sale, generally, to go towards your purchase.
Yes.
If you've got a 3-day gap, then we won't have cheque directions on your purchase in time to get the cheques
So
from the sale.
they've got a bridge findings?
Well, that, or the money has to get banked into a bank account. It takes over 3 days for bank checks to clear.
So do you still use bank checks?
Yes, at the moment,
right.
yeah.
Okay.
That's all going to change with electronic conveyancing and PEXA. So with PEXA...
Which is, that's the name of the...
PEXA is the electronic platform for conveyancing.
Right.
So we're going to start and move away from, we're going to have electronic titles as opposed to paper titles. So
right.
it's the system where we're moving away from paper-based conveyancing.
And how long is that?
It's a work in progress. At the moment, we need as many people to jump on board as possible because the system's only really going to work well when everyone's on.
So this applies, but that applies on your side of the street. So conveyancers, solicitors.
Absolutely,
yeah.
Absolutely. And I mean, the big advantage to PEXA will be that your money from your settlement will instantaneously be in your account as cleared funds.
But it's still a ways off.
Yeah.
Okay.
Yeah. Well. Yeah, until everyone's in. It's hard to answer because what happens is not every transaction you can do in PEXA yet.
Right.
So we'll key everything into the system. We're saying to everyone we're going to do an electronic conveyance, and then you might have a bank that's not in PEXA yet.
Yeah.
So then
there's all the little banks and all the rest of it.
Absolutely, yeah.
Okay, so you said to me before this. Can we speak for at least, maybe this will take about 10 minutes. So we've been going nearly 55, Colin. I think we should wind it up in another 5 regardless.
All right.
Okay, so here's one for you. How do I know a conveyancer is legitimate? Now, there's something that's come up not too long ago. I saw in the paper that somebody had run off with clients' money. How does that all work?
Well, to know that they're legitimate,
yep.
we have to have our licence numbers on our letterhead.
Yes.
So your letterhead will have to show that you're conveyance licensed. You can look up Business Licensing Australia. You can look up, they have a register, and Consumer Affairs Victoria have a register.
Right.
So if you want to check out that Colleen actually really is licensed, it's not just the things on her letterhead and on the wall, you can key in my name and it'll come up and tell you that I'm licensed.
Okay.
So that's really important.
Mm-hmm.
It's really important to deal with somebody that's licensed. If you've come across a conveyancer that's not licensed, well, it's illegal for them to do conveyancing work for money.
Right.
Unless they're licensed.
Unless like it was Aunt Mary or something.
Yeah.
Yeah.
So,
okay.
That's right. So no, that's really important.
All
Just
right.
like your solicitor can only practice if they've got a solicitor.
And same with an agent too. Yep. We've got to have exactly the
and
same.
like you, we have like solicitors, we have professional indemnity insurance.
And
all that.
And that's required as a licensed
Absolutely.
conveyancer. Okay.
Absolutely.
So we've covered the new cooling off provisions, which was really important. We've covered importance of building certificates and certificates for Section 32. Mortgage on title. So some of these sound a bit dry, but the truth is, from an agent's point of view and a conveyancing point of view, when you're in the middle of a transaction, you think it's all going to plan, and things just then start, the bricks start falling off. It's not all pretty, is it?
No.
One of the things is that's put in, one of the questions came through. Mark has said, mortgage on title, when clients say they don't have one, but it is registered on title. So what does that...
It happens all the time. What happens often is people will go out and they'll have a line of credit. So the line of credit might have a limit of, say, for example, $80,000 on it, but you don't owe any money on it. You haven't drawn on your line of credit.
Right.
The bank obviously has to register a mortgage against your title as security because you could go out tomorrow and spend the $80,000.
And then not pay back.
That's right. So that in the client's mind, they don't have a mortgage on title because they don't owe the bank any money, but the bank has a registered mortgage on title.
Yeah, so they got a lien over the
So it's as if, that's right, so it's as if you still have to do a discharge authority because we still have to get the bank to prepare the discharge of that mortgage. And that happens all the time. It's like also when we say to clients, particularly when a lot of people are selling property for their parents. Okay.
We're back.
Yeah, sorry. Where's the title? And honestly, 9 out of 10 times they'll bring me in a photocopy of it. And I say, no, I need the original title.
Right.
Okay? So most of the newer ones are blue now, just a tip for everyone, they're blue.
Okay.
So they're easy to find, but often the title, the original title probably is with their solicitor when they had their wills
What
made.
happens if they can't find it? So we've had this with older people. They put it away. They honestly don't know where it is.
You have to do a lost title application, which is costly and time-consuming.
And what sort of timeline is on those things?
It's much better now than it used to be, but you can generally get a lost title application through in a month.
Okay, and this brings up another thing: probate. This is now we're acting for a lot of families, unfortunately, that especially in these areas, and as you would too, that there's probate. Again, agents want to put it on the market. Everybody's ready to go. We're saying to the conveyancers, can you put it subject to probate?
Look, you can. I've had 3 this week, funnily enough, that we have to get probate done on them.
Right.
And you either have to do like a survivorship application, so husband and wife and one of them dies, you have to lodge a survivorship application at the titles office, transferring the title into the surviving proprietor's name. Now, I had one yesterday, a new client come to me and they're selling mum's house.
Yes.
And I said to them, have you done probate? They said, no. But we're not going to do probate. We don't want to take mum's name off the house because it's really sentimental. And I said, well, legally you can't sell it. Right?
Yep.
Mum can't sign.
Yep.
Okay, so it has to be transferred by application by personal legal representative into the executor's names.
Right.
So the executors will sign.
And how long could that take?
Really quickly, if everything's readily available, well, it depends on how quickly you get the probate done.
Yep.
So, because for me to be able to, I can draw up the APL and the survivorship application and the stat dec and take it to the titles office and lodge it, but I need a certified copy of the grant of probate.
So, is grant of probate? My understanding is it can take about 6 weeks. Is that about right?
Yeah, it depends on how exhaustive the estate is really. Right. That's probably more a legal question for a solicitor, but
and definitely worth investigating for most people.
Definitely. But so that most people know, if your house, if one of your parents have died and you're going to sell, probate has to have been granted to do a survivorship application, or if the house is just in mum's name, mum's passed away and you have to sell, an application by personal legal representative has to be lodged at the titles office before you settle.
Okay.
So if we've got an instance where we've got an agent that's jumping up and down for the documents...
You're not talking about us at all, are you?
Then we put a copy of the application or the survivorship application into
So that's okay?
Yeah, that's fine. Right. Because by doing that, we're showing the purchaser, we're really showing the purchaser's representative that this is how we're proceeding. We've got Mary Jones on title, but the contract's been written up as... Ben and Julie Jones as executors, but we're putting a copy of the survivorship or the APR in the 32, so this is our intention. And we will normally also put a condition in the contract saying it'll be registered prior to...
So we've got one at the moment where the solicitor point blank refuses to draw it up until probate's granted. So it's horses for courses, isn't it?
Absolutely.
So look... Colleen, we've gone for nearly an hour and you said 10 minutes. We could probably do another hour easily, and Facebook will log us out after an hour and a half. But what we're going to do is we're going to finish now. I'd really like to thank Colleen from Cheltenham Conveyancing.
Thank you, Steve.
It's, the information is just fantastic. If you want to speak to Colleen, or as I said, any of her team, give Colleen a ring at 958 56 222. She'll look after you. They're wonderful. We've known them for as long as we've been in business, which is about not quite as long, but 30 years or thereabouts coming up to. As I said, my name's Stephen Aitken from Aitken Real Estate. You can give us a call at 9583 0996. Speak to me or any of my team. And again, thanks, Colleen.
Thank you.
It's been fun.
It has.
Cheers. Bye.